All right, good afternoon, everybody, and welcome to today's MSHA webinar series in the Conn Maciel Carey 2025 MSHA webinars, a deep dive into unwarrantable failures. Looking forward to a great discussion today to talk about one of MSHA's more um, commonly used elevated enforcement actions, but one that's still not well understood by a lot of people unless you've had the unfortunate experience of navigating 104D citations or orders and what kind of goes with them in terms of the potential impact on your operation during the day, what happens afterwards in terms of follow-up investigations and how we navigate abatement, and then the challenges that pose themselves during the contest process. So a couple items that we'll talk through. Hopefully, you now never have to deal with them, but we should be well prepared after today to at least give you guys the groundwork to respond in the event that they're issued. Thank you for joining us. My name is Nick Scala. I'm a partner here at Conn Maciel Carey and a chair of the MSHA Workplace Practice Group. Thanks to you, those who have come back for another webinar, and welcome to anyone who's new to it today. I represent companies all over the country dealing with MSHA and OSHA, whether from rank and file inspection to complex investigations after incidents, or well, something we'll talk about today, agent investigations following the issuance of warrantable failures. I've been doing this for the entirety of my career and look forward to continuing to work with industry and you all as we push forward. I'll let my colleague Emily introduce herself and then we'll go ahead and get into today's discussion.
Hi, everyone. My name's Emily Scott. I am a senior counsel here at Conn Maciel Carey. Like Nick, I mainly represent mine operators in interactions and litigation with MSHA and all the various forms that takes. And before I joined the firm, I spent just over 10 years with the Department of Labor, the vast majority of which was actually advising MSHA on enforcement policy and rulemaking and conducting litigation. So I have seen a lot of the flip side of what we're going to discuss today.
Great.
Speaking of what we're going to discuss today, we'll just start with a quick overview of our agenda. First, we're going to cover the definitions of unwarrantable failure. Where do they come from and what are they? Then we'll discuss kind of the mechanics of unwarrantable failure issuances. How do they work? What are the various types of issuances that can be unwarrantable failures? And then we'll talk about some of the ramifications of unwarrantable failure citations and orders, be that penalties or other enforcement implications. And then, as Nick said, we'll spend quite some time talking about Section 110 investigations, which can result after unwarrantable failure issuances. And we'll wrap up with kind of an overview of contesting unwarrantable failures, what the options are, and advantages and disadvantages for several of those options. So we'll start with the basics. What is an unwarrantable failure? So the terminology comes from Section 104D of the Mine Act, which allows MSHA to issue a citation. Well, first a citation, we'll cover that more later, but allows MSHA to take enforcement action if an inspector determines that there's a violation of such nature as could significantly and substantially contribute to a hazard, and if the violation is caused by an unwarrantable failure of the operator to comply with a mandatory health or safety standard. Now, the statute does not define what an unwarrantable failure is, but over the years, the Federal Mine Safety and Health Review Commission, which we'll talk a little bit more about later, has kind of put some meat on those bones and has said that an unwarrantable failure is aggravated conduct constituting more than ordinary negligence. Some of the different descriptions the commission has used over the years are reckless disregard, intentional misconduct, indifference, or a serious lack of reasonable care. So this is more than just your garden variety negligence, usually not a moderate negligence situation. It's going to be something more akin to high negligence or above. Now, determining whether that aggravated conduct exists, the commission has also, over the years, refined several factors that go into determining what an unwarrantable failure is. And MSHA also, likewise, trains inspectors to consider these factors as well. So the factors are the length of time that the violation has existed, the extent of the violative condition, you often physically, like how much of the mind does it affect, but not necessarily just physically. Whether the operator has been placed on notice that greater efforts were necessary for compliance. That often goes to is there some evidence that this has happened in the past and the operator knew about it and hasn't taken any steps. And we'll talk more about that later too, because that poses problems or challenges sometimes with inspectors' interpretations. And additionally, we look at the operator's efforts in abating the violative condition. So did the operator take any steps to correct the violation kind of before the citation or order was issued? Also, whether the violation was obvious or posed a high degree of danger, and whether the operator knew about the existence of the violation. Not all of these have to be met for an unwarrantable failure to be issued. Technically, if one of these is there and significant enough, there can be an unwarrantable failure. But in the vast majority of cases, there will be some combination of all of these factors, some of which may be more important, some of which may be less important under the circumstances for there to be an unwarrantable failure. Where do we often see unwarrantable failures issued? A lot of times, if a supervisor is involved in an allegedly violative condition or practice, or if a supervisor has ordered an allegedly violative condition or practice to be undertaken, you might see a D. If MSHA has issued an imminent danger order, there might be a 104D issued, especially if a supervisor is involved. If there are repeated or widespread issues in a mine, that's often the types of similar violations recurring over a period of time, especially if MSHA has previously issued citations for those conditions. And we often see inspectors claiming that operators are on notice for a variety of reasons, even if there haven't been citations issued. Additionally, if complaints have been called into MSHA, either from minors or from others, sometimes those will result in unwarrantable failure issuances. And also, very often, after an accident investigation, whether fatal or non-fatal, MSHA will issue unwarrantable failures. So there are some other considerations for these. In addition to those 6 factors we discussed a few minutes ago, all relevant facts, including mitigating circumstances, are considered. So in addition, it's not as though there's, a very rigid form where only those 6 things can go into this analysis. MSHA, and if it comes to litigation, the commission will consider kind of everything that's relevant around the circumstances. As we discussed, some factors may be more important than others. Often you'll see if there is an extremely dangerous condition, then the seriousness of that danger may outweigh a lot of the other considerations. An unwarrantable failure in whether in litigation or just discussions with MSHA before litigation is pretty hard to defeat. But there are some defenses that the commission has recognized. The most prominent of these is that if the minor involved had a reasonable good, or the operator had a reasonable good faith belief in the safety of the cited conduct, that can be a defense. There was a recent case on this that came out from the DC Circuit a couple of years ago that involved a foreman in an underground coal mine who got called to an area where some contractors were drilling because the methane spotters were alarming that methane was over 5%, which is in the explosive range. So the foreman sent most of the miners out of the mine, but decided that what had happened is they had drilled into pockets of gas that was releasing the methane. And so the foreman decided that they needed to plug those holes. Well, the problem was the bits were still in the holes. So rather than de-energizing the drill and shutting down work, which is what the standards require, the foreman directed some miners to continue operating the drill to pull the bits out so they could plug the holes. Fortunately, there was no accident, but MSHA issued unwarrantable failure citations and orders under the circumstances, and this was appealed. And there was also agent liability for the foreman, and Nick will talk about that in a bit. This was appealed all the way up to the Court of Appeals, and the foreman's defense was under the circumstances, it was more important for me to plug the holes to stop the methane from getting in, and I reasonably believed that to be safe. And the Court of Appeals said, well, you might have good faith believed that, but it just wasn't safe under the circumstances to run energized equipment in explosive methane. So you can get a sense from those facts about how challenging it can sometimes be to prove this defense. And the last quick point on this is the commission has sometimes recognized a defense where a supervisor engages in conduct that places only themselves and not other minors in danger, but that is not available if an operator is challenging an unwarrantable failure citation. So limited set of defenses in litigation for these. I think Nick's going to take over from here.
Yeah, but I am. Thank you. And Emily, I wanted to get your thoughts on one item when we were talking back here on the elements of unwarrantable failure, or really what is considered aggravated conduct. So one item on there is, and we're going to talk about abatement in the next couple of slides, so I think it makes sense to kind of jump into this here. But the operator's efforts in abating the volatile condition, right? It's the top one on the second column there. So I guess what are your thoughts on a situation where, an adverse condition is found, say it's found during the workplace exam that day, and then the operator, though, doesn't have the ability to fix it in the moment, or maybe the equipment, maybe they have to order specific parts. And then MSHA comes out and issues an unwarrantable failure because they say that the operator and management had knowledge that the condition existed. What kind of steps should operators be paying attention to in that moment to argue that an unwarrantable failure is not appropriate, and or what should the companies be doing to try and mitigate operation with that condition in place, or evaluate whether they can operate to avoid a potential unwarrantable failure?
Yeah, that's a good question. I think it definitely depends on the precise nature of the hazard. So you had a couple of examples. Let's take one where there's a piece of equipment that needs a part to be able to run safely. I think under those circumstances, tagging it out, putting it in a designated area that indicates that it's not for service would probably be considered efforts in abating that violative condition. My experience with MSHA is that inspectors can be reasonable and they understand that parts might take a couple of days to arrive, but kind of leaving a vehicle in a place where it's available for use would probably not be considered adequate efforts in abating that violative condition. And then if there are issues with respect to like an area, um, one option might be barricading, signage posted to prevent entry, indicate rather than just assuming it's going to be fine for the one shift or whatever it takes to get a problem corrected is not going to be enough. So some effort is going to be needed to trying to basically to limit minors' access to the hazard, I think, is what I'm getting at here.
Yeah, and I think that's exactly right. I mean, I think, sometimes conditions are found. We can't correct them immediately. So we have to make a determination of, one, can we safely operate in the condition that we are in until we get that new part? Or someone can access the area to perform housekeeping if it's spillage that occurred on a shift before. And I think you're precisely right there. We have to look at mitigating circumstances or interim protective measures that we can put in place. And those are often things that should be brought up if we get into a situation where MSHA wants to issue an unwarrantable failure for a condition, but the circumstances exist. So, for example, like Emily said, if you have an area where maybe you need a guard installed because the guard broke or was damaged on the prior shift, but you can't shut down that area without shutting down the entire mine. Perhaps you can barricade the entire area. You can put that signage up. You can have a meeting with everyone on the team and say they're not allowed to enter that area without it being locked and tagged out until that guard is repaired or replaced. But those are the kinds of efforts that, I think Emily on the slide before was talking about. It's aggravated conduct is indifference. So you did nothing. You knew about it and you did nothing. If you're taking these affirmative steps to protect against that potential hazard, you should be eating away and eroding this claim of aggravated conduct and unwarrantable failure. But it's important sometimes to remind MSHA if those steps have been taken as you move forward. And, I brought that up in the context here because a big part of it is that we're going to get into this is that once we get these unwarrantable failures, they can build upon themselves. And the challenging of them and the contest of them, we have to be careful with, as we'll talk about here as we get through this presentation more. But one of the reasons that we have this concern and really want to stop them before they're issued, right? The best time to get out of a citation is before the inspector writes it down, just like with a police officer and a speeding ticket, right? Once it's reduced to writing, you're toast. You're going to get it, and you're going to have to deal with it. But if you can offer some of that mitigation to the inspector, maybe in the moment, you might be able to navigate getting it be a high negligence 104A as opposed to a 104D. And part of that is, 104Ds have higher penalties. There's a potential for 110, which we're going to spend some time on. But also, there's this concept called the D chain, where if you get an initial 104 D1 citation, right, because it always starts with the 104 D1 citation, if you receive another D or another warrantable failure within 90 days, that is a D1 order. Now, the difference, and we've talked about this on prior webinars with MSHA in the citation versus order is typically, and in really all instances, if you get a citation, whether that's a 104A citation or 104D citation, the operator is permitted to abate it, correct it, and then continue operation until MSHA verify, and then MSHA will come back at a later point in time or ask for verification to be submitted that it was corrected, right? That is a citation. If MSHA issues an order, that is a shutdown or withdrawal from active operations of that piece of equipment, a specific area. It could be a processing building, depending on what the conditions are, whether it's dust related or is it going to be safety related. But these also require approval before you can resume operations. So, you know, defeating that initial 104D citation, if you can defeat that, then every one other unwarrantable failure falls away and goes back to a 104A unless MSHA asserts and proves the elements that it can stand on its own as an unwarrantable failure. And then it could become the 104 D1 citation, but you still have kind of a break in this chain. So that D1 citation is what starts. If you receive another one unwarrantable failure within 90 days, that's going to be a D1 order. That now gets more onerous. It's a shutdown. Need MSHA to approve it. Um, and then after that, any subsequent unwarrantable failures issued are going to be D2 orders. And now D2 orders are going to have higher penalties. The more Ds you get, there's going to be a much higher likelihood of agent investigations, regardless if there was an injury. But there's no timeline on another 90 days, right? You are just on this D chain where if you get that second 104D, that second unwarrantable failure within 90 days of the first. Um, and then in order to break that, you have to go through and MSHA has to conduct a complete inspection of the mine without finding any similar violations, any unwarrantable failures. Now, that is supposed to be an inspection of the entire mine. It doesn't necessarily have to be an EO1 inspection. Sometimes inspectors will say that. The commission case law says that it just has to be an inspection of the entire mine, and that could be done through, a spot inspection or some combination of inspection types but every area is actually going to be viewed. And if you go through that, and you can go through without any unwarrantable failures, then you've broken the D chain. And if the next time an unwarrantable failure is issued, it's a 104 D1 citation again. We restart, you have 90 days in order to get another unwarrantable failure, and that would be a D1 order. And if you don't receive anything in that 90 days, then if there's a subsequent 104D found, it's a 104 D1 citation again. So it's It sometimes can be quite difficult though when we get on the D chain to get off of it, especially if we're having ongoing issues, maybe on a specific topic like housekeeping or guarding. These can often be situations where, they come a little bit self-fulfilling, and then the inspectors that are coming out, if even if it's not the same inspector, know there are these issues. So this whole concept that you're on as an operator, notice that greater care is required, you that box almost is always checked immediately because you've received unwarrantable failures in the past. Therefore, you should have known that you got to have your site really buttoned up and addressed, especially when it's related to the same issue in terms of maybe housekeeping or guarding, like we've said, or dust control. And so it gets a little bit easier for them to justify issuing more Ds. So really, when these Ds are issued, we need to focus on abatement and not just putting a Band-Aid on something, but really looking at the root cause of what's an issue if we've got multiple 104Ds and getting to correct that so that we can, one, ensure that our site's safe, but two, eliminate this kind of development of aggravated conduct because now we did act appropriately in term and when we were put on notice that greater care was required. Like we implemented change, we put in new equipment if necessary, we retrained our team. And that can all go towards kind of breaking this chain, or if we receive subsequent citations, maybe now they're going to be A's instead of D's because of those efforts that we put in, right? Because that goes directly to operator negligence. So something that has to be considered as you go through it and you kind of modify and develop your strategy of response. But understanding that these can really build upon themselves, and sometimes if you're not taking really affirmative and assertive action to limit what is occurring on the 104Ds and address them, you can get quite a few Ds very quickly. And then you are under the thumb of MSHA and the inspectors in order to get yourself back up in operation and get their approval to continue operations in a specific way. The other side of this is they're just going to be more expensive, right? You're going to have a normal citation. The baseline is $168 right now. You get your 10% off for good faith. If you're not receiving a D, you don't get that usually with a D citation or order. But the baseline for a D1 citation or order is $3,000, right? That is the minimum. Um, the 104Ds, twos are more expensive, double. So the baseline for that is $6,000. So the penalties increase pretty quickly. And that's the bottom, right? Usually there can be much higher than those minimums. They are going to be capped at that 90,649, which is a statutory maximum for a non-flagrant penalty. But it's not uncommon when you have several 104Ds issued to see them in the 20, 30, even $40,000 range, depending on the circumstances and the type of issuance and how MSHA goes about that. Um, it can go up to MSHA's max penalty, which is at 332,000, but that's only if it's going to classify as a flagrant violation. So, typically though, the 104Ds are going to be limited by that max of 90,000 and change. Now, in order to get up to penalties that are in the 20 and $30,000 range, oftentimes that's because these are going through what's called special assessments with MSHA, and special assessments, it's a bit of a black box, but essentially MSHA calculates what the penalty would be, and maybe that's based off their penalty calculation system. And for a 104D, it might be the statutory minimum, right? It's going to be a $3,000 penalty. But then MSHA, if they, as an organization, don't believe that that is necessarily the right amount to be kind of punitive in nature, right? Because that's what MSHA penalties are meant to be. They can put it through special assessments where they evaluate it, and typically what happens is they add additional points to that calculation um, based on negligence to result in a higher penalty. Um, it can be a frustrating process. There's not a lot of transparency there. They give you a readout that pretty much just regurgitates the language of the citation as justification for increasing the penalty. Um, we saw that a fair bit during the past few years of the Biden administration, the use of special assessments. Um, Special assessments fell off pretty aggressively their use during the first Trump administration. So perhaps with confirmed leadership at the agency now, with Wayne Palmer now confirmed and sworn in as the assistant secretary, we might see more policy changes there and with the use of special assessments. But I can just say, in the last year, right, in 2025, during the Trump administration, we've continued to see active use of special assessments, especially on 104D. So that's how these, turn from a $6,000 minimum into a 20 or 30 or $40,000 citation pretty quickly. Additionally, you're going to get into scrutiny for more inspections, right? Spot inspections, impact inspections historically, although those have seem to have fallen off since the new administration took over, or at least they're just not reporting them. And then also consideration, these are elevated enforcement actions for the purpose of looking at your pattern of violations. Now, that's also something that we don't think is going to be too active in the next few years, but it is a formula. There are boxes that get checked when they run a POV screening for all mines, and 104Ds are certainly going to be an issuance that kind of ticks up your qualifications there. In terms of avoiding them, some of these are pretty low-hanging fruit, right? One, our workplace exams are going to be probably one of our biggest tools. Do our workplace exams, do them well, address things quickly when they're observed, right? If we have any reports of adverse conditions from our workers, or if anything develops, we need to take quick action, whether it's corrective or preventative, to address a hazard. This is especially true if it's obvious, right? It's open and obvious. It's really easy to see. These are going to be the ones where it's obviously easier for MSHA to say management knew or should have known, therefore high negligence is going to qualify, and we start ticking those boxes on aggravated conduct if it's, the high wall has crumbling parts and everyone works in the same area. Those are issues that we need to address immediately. We got to have our company policies. They need to be laid out. We need to train to them. Our employees need to be aware of them and held account to them. And, doing that can also one, help us maintain a safe workplace, but two, if there's questions about were we actually enforcing it or did we know of adverse conditions, if we have a history of enforcing those policies, those are all things that help us drive down negligence, which get us away from aggravated conduct. Part of that is performing, audits of our site. Are we complying? Are we maintaining our programs? Are we enforcing them uniformly in the event that non-compliance is observed? And then also just review all abatement and termination timelines with the inspectors, right? One thing that we always have to be wary of, even when we get a 104A citation, is that sometimes these randomly assigned termination deadlines. And making sure that we are taking action to correct a condition or taking actions to prevent access to it, like Emily and I were talking about earlier. And, this often kind of comes up in terms of 104B, right? If an inspector comes back the next day, did you do anything to abate this? There might be a failure to abate. But if it's what they consider a really hazardous condition or a really widespread condition, and you haven't gotten to it or done anything to correct it, this could also be the basis the next day for a 104A that was issued the day before to turn into a 104D issued the next day. Because the condition has continued to exist or maybe developed further, and we haven't taken any steps to abate it or terminate it or protect against it. So beware of those items, and also, just make sure that if you see a condition developing, you're doing something to address it, right? We can't sit and put our head in the sand and just say, we'll get to it later. We're really busy today. Or we really have a lot to do, a lot of trucks coming in for loads. You have to act quickly on these things. And part of the reason for that, and what all managers and supervisors should know, is that there is this personal liability that's often tied to 104Ds, right? And that is outlined in section 110 of the Mine Act. And these aren't a guarantee that they're going to take place when a 104D is issued, but these investigations do frequently occur following 110s, especially when we have accidents or injuries and resulting 104Ds issued from them, but that's not even a requirement. But at a high level, the Mine Act allows MSHA to assess civil penalties against individual agents of the company um, who knowingly authorized, ordered, or carried out a violative condition of a mandatory standard. Um, these are usually civil penalties, like I said, so fines that can be in the thousands of dollars. I mean, usually for an individual operator, if you go through a 110 and, say that you get to the point where MSHA is assessing a penalty, I mean, that can be somewhere between, three, four, $5,000, even more. It's usually not nearly where the company is assessed, but it's not a insignificant amount. And if there's multiple 104Ds being investigated for 110 liability, you can receive an individual penalty for each one. So it's incredibly important that we, take these seriously. And for individual operators, I mean, there is personal skin in the game, right? You should be aware of this because 104Ds are serious from what they require the company to address, but also there can be personal liability there. It's the most important factor is going to be though manager supervisor knowledge and negligence, right? What did they know, and did they or should they have taken action to correct it? Um, Rare, but also on the table is that they can refer this to criminal referrals to the Department of Justice. Don't see that very often. There are circumstances where it happens, typically reserved for situations where people have been caught lying and or falsifying data submitted to the agency. Um, but it is something that people just should be aware of that is in power that MSHA has when we're talking about it specifically from the context of 110C liability. So this is going to be the civil penalty. It's against agents of management. It gives MSHA the ability to propose assessments against a director, officer, or agent of a corporate operator who knowingly orders, authorizes, or to carry out that violation of a mandatory safety and health standard, like we talked about at the last one. And they can also pursue criminal proceedings against an agent who willfully violates a mandatory standard. Um, this is going to be similar to what we see as a burden of proof that they have to go through to proving the citation, right? It's got to be by a preponderance of an evidence that a civil violation occurred in order to put out that assessment and that penalty. So, it's not the standard, even though it's against an individual of beyond a reasonable doubt, although that is reserved for the people who are going to be prosecuted on a criminal side. Again, that's very unlikely, but you do have a burden there if there's going to be criminal actions that are proposed. Um, it's again, that's a very different standard. It's willful, it's done knowingly and purposely by the operator, having free will and choice, either intentionally disobey the standard or recklessly disregards its requirements. So a pretty hard line. It is really a situation. There has to be intentional action to really ignore something or definitely to put people in harm's way in violation of a standard. And some of the times where we see this on the criminal side and on the civil side, it has been in the last few years, right? There was a big case that in the Eighth Circuit over the last few years, it was called for agent case out of North Shore Mining, and that involved an interesting evaluation of where the line in liability with knowledge versus ability to act or control was. So in that situation, as it plays out, and this is a gross oversimplification of what the facts were, but essentially there was a walkway at the mine that was in not a great condition. There was an engineering report that existed at some point in time that said this walkway needed repairs. The mine had been idled for some time or another in between, um, because that's just the nature of the operations up at this location. Is very economically driven, and essentially you had a couple managers who had a contractor out on that area. Um, in the condition before anything had been done to correct it. And so MSHA eventually issued some 104Ds, did a 110, and part of the operator defense, or I should say the agent defense, was that they did not have, while they might have known about this engineering report that said it was unsafe, they did not necessarily have the ability to shut it down and order repairs and implement the changes that were in this report. And what the Eighth Circuit said is that doesn't necessarily matter, right? If you are an agent of the company, there is something that you could have done in order to prevent this, and you're obligated to do it. So, you can't hide behind, well, as a supervisor, I might have known that that equipment was running without a guard on it, but it wasn't my place to stop or get a new guard or barricade the area. I'm just not going to necessarily look at that as a situation or mitigation on a 110. Um, Additionally, with criminals, or criminal cases and prosecution, it's pretty limited. As I said before, there was a case where there was falsification of dust sampling records and monitoring. That was broadcast in the last few years. I think the facts there, at least, were that it was an underground coal mine and they had the pumps running in a supply closet on the surface and were certifying the data as being from the working face. Obviously, that is a pretty egregious offense. And that is one situation where you can see that MSHA could go criminal there. They did against the operator and the agents. There was another instance where there was a failure to report an accident that eventually led to a minor's finger amputation, and then also falsification of training records. These are things that we should know not to do. Um, and I always tell people this that, very often trying to cover up some kind of offense is going to be a much worse outcome than if you just kind of own up to a deficiency, even if you may have been aware of it, but trying to cover up or falsify records or move things around or lie to the government after the fact is often going to result in a more heavy hand than if you simply just messed up on that situation. And then kind of an unusual situation, but MSHA also broadcast recently that they worked with assisting a state um, in indictment of a mine operator and a manager following the death of a miner, and that was interesting because the timelines moved much more quickly than MSHA did on the 110 side and on the issuance side, but the agency nonetheless was kind of pushing forward a case or helping the state push forward a case that led to agent liability, albeit not under the Mine Act. So, uh, very serious things that we have to work on. We need to be aware of them. Not trying to fearmonger or scare anyone, but if you are a supervisor, you should be aware of these possibilities, just because it underscores the importance beyond safety and health of making sure that you are taking these seriously, addressing any situations quickly. Um, when we see these 110 investigations, there are general timelines that the agency is supposed to be following. These are included in MSHA's Special Investigation Handbook. I will say these are very flexible. Now, MSHA's a bit better about it than they were maybe, 5 to 10 years ago on their timeliness, but still, the 110s, they typically kick off within a month or two of the issuance of the citation or the order, the 104D, in this case. And then once they do, um, you have a time period where the agency is going to go through and they're going to do an investigation. Then there's review at the district level. There's recommendations and review to go to the Technical Compliance and Investigations Department, or TCID, at national. If they continue to move it forward, there will be additional delay while these penalties are run through the Office of Assessments. And then if there's a criminal referral, you have even more time after that, right? Up to 240 days. And like I said, these are flexible. There can be changes and significant delays. So these often take a long time, and can be very fast-paced when you get an investigator who's initially assigned one, and then they'll slow down significantly. We had one where we helped a client where the investigator showed up, wanted to conduct interviews within 48 hours and requested documents and then was not heard from for months. Um, and we haven't received a closure letter on that, although indications are that it is being closed out. And then there's delays at TCID with issuing letters that close out investigations. So they can just take a very long time and really seem to get drawn out. So you have to continuously try to flag them. The other part of this is that with special investigators, the TC or the 110s definitely take the back seat to 105Cs and other types of investigations. And so often you'll see someone have to stop a 110 in the middle of it, reschedule something, and then address maybe a whistleblower complaint under 105C. So again, those are tentative dates, but they give you an idea that it can be drawn out for an extended period of time. The goal of a 110 is to identify information leaking management knowledge to the conditions prior to the issuance or prior to the incident. They're going to look at documentation. They're going to request documents from the company, but primarily they're going to be looking at interviews and they're going to be conducting interviews with agents of the company and also with just the rank and file minors. And usually one of the first requests that we see in a 110 is for the personal contact information of minors on site. Um, Unfortunately, it's not something that you can really outright refuse. There's case law saying that MSHA is entitled to the information. We can try to limit that maybe to a specific shift that or a specific area if we have a large group of people that are working at the mine that are unrelated to it or had no exposure or knowledge of it. But usually that's the first thing because MSHA is going to want to do these interviews quickly. It's important as we get into this that we always remind everyone of their minors' rights when we go through this, right? So every minor, management included, has a right to speak with MSHA voluntarily or decline to speak with MSHA confidentially or alone, or with a representative of their choosing present, whether that is another minor, a friend, a family member. It can be a member of management, although MSHA will typically balk at it being the person who's under investigation, and they might not like the fact that it's a member of management, but it can be if that's a minor's choosing, or it can be an attorney. Whether that's a personal attorney or someone from the company attorney that has been made available. It's entirely the right of the person being interviewed who they want present with them if they do want someone present. Um, Anyone can write a statement for the MSHA or investigator or decline to write a statement or sign a statement or decline to sign a statement. It's really the minor who controls it, but it would be important for everyone to know that, MSHA is going to come at this from a pretty aggressive standpoint. These special investigators are known to show up at people's houses, to call their cell phones after hours, to, really kind of put people in a position that they, feel like maybe they have to talk because it's someone in law enforcement. But still, these rights carry forward as soon, throughout the process, and even if someone is at home, right, they can tell the inspector, hey, contact me during working hours. Oh, set up a time and I'll interview with you at the mine, or they can speak with them right there and then. So it just depends, but this is going to be the primary source of information that they are looking for. So supervisors, if a 110 is happening, prepare to be questioned. Initially, recommend that a supervisor has legal counsel present and involved in this kind of early and often before you really sit down and talk with MSHA so that we can help you evaluate what that liability might be, how we defend it. But it's your choice. Obviously, you have those same minor rights, but you can always tell them that you want to reschedule at a later time. You don't have to feel obligated to sit and speak in that moment. And it's kind of a silly process because MSHA comes out and these investigators often drive hours in order to hand deliver a notice or a letter that says you're under 110 investigation, similar to what they do with 105C. And then they might say, well, I drove all the way out here, so why don't we just talk about things now? You're under no obligation to do that. MSHA has email, but they do this, and it's a little bit of a strategy to try and get you in that moment. because they're already out there. And I had one recently with a client. Emily and I were working with them. The investigator drove 4.5 hours to the mine just to deliver the letter. And then the company said, no, we'll schedule interviews at a later time. And so the investigator drove 4 hours back. I mean, it's a crazy waste of time, but that's often how they go. So don't be afraid to tell them that you're going to schedule an interview at a later time, especially if you're a supervisor. Um, if you ever do make a statement or they ask you to read a statement that they've typed up, um, I will just say that you should make sure that every I is dotted, T is crossed, period is and punctuation is appropriate because if you sign it, they are going to say that you deemed it 100% accurate. So you're not required to sign anything. Just in general, be careful signing documents at any point. Now, MSHA doesn't have subpoena authority, but they do have pretty broad authority under Section 103H of the Mine Act, so they'll likely be requesting documents. A lot of these are going to possibly even be documents that were submitted to MSHA during an inspection, like workplace exams or training or pre-shift for mobile equipment. But it can even expand into other things like production reports or safety and health policies or procedures or investigations and statements. Typically, we turn these over and we participate, get them to MSHA because we have limited arguments on really pushing back. But if something is truly not relevant or overly broad or overly burdensome to produce, we can push back on those. And if needed, challenge whether or not we're going to seek them. But usually, MSHA has broad authority here, so we typically try to work with them on that. And if we see some items that maybe we need tweaked, we try to have those discussions early with the investigator in order to limit that or try to limit those items. Just basic strategies. If there is an unwarrantable failure issued, the named supervisor, the one who's maybe the front line, we recommend that you don't really participate in the remainder of inspection. Right? Hopefully, you got some additional people on site trained. You tag one of them in to come out and walk with the inspector the rest of the time. You don't participate necessarily in the closing conference. And we'll talk more about informals here shortly, but you don't participate in the informal. And that's because anything you're saying is getting added to the record at that point and can be used to kind of help justify one, more severe penalties on the 104D, but also to help build that case on the 110. If you're the only supervisor at your mine or your location and you don't have a choice but to continue participating, um, just be a listener rather than an active participant in discussion. And at all times, avoid arguments and really fighting with the inspectors because, in those heated moments are often when we make statements or that we regret or may not be fully accurate, or the recollection of what is heard by the inspectors may be a little more um, inclined to focus on the negatives than what we really want to convey. So just be careful of that as you're pushing forward. As I mentioned, these can be long and drawn out, so you'll have to be prepared that we might have the same conversation with MSHA a couple times from an inspection to an investigation. Um, the best avenue is typically the truth, as I said earlier, right? A simple, honest explanation. Sometimes you're going to have a mea culpa. And you're going to have to fall on that sword. And if that's the case, then you're just going to have to maintain it. Where you start to have issues is what I talked about earlier, right? Changing stories, changing documents. That's going to really, prick up the ears of these investigators that maybe someone's not being truthful. Maybe someone is trying to change the record here or try and get ahead of something or cover themselves on it. And that's usually where these investigations have a propensity to really, really take a turn the wrong direction. In terms of best practices, engage legal counsel early and make them aware of it so that they can help you navigate it, whether that's in-house or outside counsel. These aren't situations where it's the best to wait and see how it plays out and then try and get legal counsel to help you. Often at that point, the damage is done. So it's always good to get counsel involved as early as possible so that we, being counsel, can help you navigate these challenging situations and how we best want to move through them. Document your recollection of events. about on the time of issuance. What led to the condition? Why do we think it isn't appropriate to be 104D? Preferably you're going to do this after you speak with your attorney, because we will instruct you to do that for us. And then we can claim privilege of those notes because they're being prepared at the direction of counsel. And we are going to know at that point that we're likely going to be in litigation at some point here. So it will bring that under attorney-client privileges and some of those. Um, do not at any time try and, corner an employee, threaten them, influence their statement, create a story for everyone to kind of remember where we're at. Those are obviously things that, are going to have the real propensity to blow up in your face. Because MSHA is going to ask these people in their interviews, were you told to say anything? Were you coerced into saying anything? Were you threatened? And if the answer is ever in the affirmative there, again, it's going to go poorly very quickly. So, don't do that. Just tell everyone what their rights are. Tell them that we stick to the truth, whatever that might be, and we push forward. And also, if the truth is not what we need to hear as an operator about a supervisor, you need to know that as well so that you can correct the ship and make the site safe for everyone on it. As I mentioned, just kind of limit the involvement of supervisors moving forward after if we find out that 104Ds are issued, um, and make the minors aware of their rights as you move through the process. Now, a couple other aspects here that are interesting, and Emily will jump in here for here shortly too, is the contest options because they're slightly different with Ds, and we have to take a slightly different approach. So, as we know, we have informal contest and formal contest, right? Formal contest is when that penalty comes out, or we file a notice of contest, both of which Emily will talk about, and we get in front of the commission. And we have options there about how that kind of plays out. And in some instances, that is our better option. We think it's our better option here with 104Ds. The other is informal, right? Informal contest, known by many names in the MSHA world, 10-day conference, district manager conference, pre-assessment conference. But you got to have that request submitted within 10 days of issuance of the citation or order, or 10 days of receipt by the company. It has to be submitted and it has to be approved by MSHA, right? And now, technically, when we're doing these, the inspection file or the case file is still open. So that's important to think about here and note because your arguments that you're presenting in the informal conference to justify being granted are going to be included. The notes of the CLR are going to be included in that inspection file. Any photos you submit, any statements you made that are recorded in the notes are going to be included in that file. So, those are important considerations here because we really don't know within 10 days, one, is there going to be a 110? Are these going to be specially assessed? It's very early and often, if we aren't very careful at those points in time, we might, have a situation, where we say something again that makes matters worse or maybe leads to a 110. So just be careful there. The other thing to consider is 110s, or I'm sorry, informals is that with 104Ds, these aren't these aren't typically issued just by an inspector in the field of their own discretion. Right. They have reviewed this with their field office supervisor who has, agreed with issuing a 104D. I mean, potentially even gone up to the district depending on the circumstances. So a lot of times MSHA just denies or can denies informal requests on 104Ds, because they've already agreed that they think a 104D should be issued. But even if they grant it, we should be cautious about it because that file is still open. And also it's not a negotiation, right? It's not like an informal with OSHA where it's after the citations are issued, after this penalties are issued, and if we don't settle at the informal, we don't settle, right? An MSHA informal is pleading your case to the agency, and then they have all the power. They can either vacate the citation or order. They can modify and reduce the severity, negligence, or other designations. They can take it off of 104D status, or they can uphold it as issue, or even make citations and orders more serious. Now, the last one rarely happens, there was one CLR or two around the country, a few years back who maybe had a propensity once or twice of making things more severe. I even had a case where someone went into an informal with a 104A high negligence and left with an unwarrantable failure. That doesn't happen often, but I think that gives at least some context to the fact that it can happen. So informal conferences have their place. I really don't think that they are appropriate when we have a 104D, unless we have some absolutely great facts about why something should not be an unwarrantable failure. And even then, I think we need to be careful about engaging on that. And then with that, Emily, I'll turn it over to you to talk about the formal side.
Right. So as Nick said, excuse me, an informal is not always the best option. So what is left? Oops, sorry about that. That leaves us with the formal contest. So the formal contest puts the case before the Federal Mine Safety and Health Review Commission. FMSHRC is created by the Mine Act, but an administrative court that is dedicated to hearing disputes between mostly mine operators and MSHA. So primarily, or these cases will start at the administrative law judge level. We call them ALJs. They hear cases in the first instance, and then their appeals, which we'll talk about in a moment. The mechanics of, oh, sorry, I've got myself all twisted up on my slides here. We have mechanic. Okay, we'll go through the process. Sorry. So the formal contest process here is the administrative law judge will issue an initial decision on the case. If a party doesn't like it, they have the right to appeal to the full commission, which provides appellate review of ALJ decisions. That's discretionary, so the commission doesn't have to take the case. After that, appeals are available to the federal courts of appeals, which is usually to the court covering the state where the mine is located. And from that, all the way to the Supreme Court, which doesn't happen very much for MSHA cases, but does happen occasionally. So the process here is timing is everything. There are two options for formal contests. One is confusingly called a notice of contest process. This is actually challenging the citation or order itself. So the process for that, you have 30 days from receiving the citation or order, and you actually file with the Federal Mine Safety and Health Review Commission itself saying, I want review of this citation or order. And we always recommend challenging or filing notices of contest on 104D citations or orders just as a means of preserving rights. These notices of contest can also be really important if there's a dispute about abatement. So like Nick said, you're going to be required to get MSHA's approval to begin operations again if there's been an order. If MSHA won't give it, or if there's a dispute about the area that's affected, or about what is required, then notice of contest is going to be your best way to get some independent review of those disputes. Separately, there's also contesting the proposed penalty. So after MSHA issues the citation or order, usually a couple of months go by and then the proposed penalty assessment comes in. Very important to file the contest to that proposed assessment. If the contest is not timely filed, it will become a final order not subject to review, and it's very difficult to get around that bar. So you file the contest to the penalty. It's also very important to note not to pay the penalty even if the citation or order itself has been contested, because paying that penalty will essentially be deemed an admission and the commission will dismiss the contest. So it's a little perplexing, but it's good to take both routes here to contest the citation or order itself and then the penalty. And then separately, if you do have an agent investigation that results in the issuance of a penalty or penalties, those 110C agent penalties also have to be separately contested. Our experience is that generally these citation challenge contests, penalty contests, and often even agent penalty contests will all be consolidated so the judge can hear them all together. The penalty contest, of course, we talked about this a little bit. but it's very important to get those in within 30 days of receipt by the company. You're looking at here the cover sheet that goes out on MSHA proposed assessments. Um, MSHA counts the 30 days from the receipt that is going to be triggered by the signature on certified mail. So it's very important to keep track of that deadline. If you're not sure exactly what MSHA's deadline is, or it was received in an office and you're not sure when it landed on your desk, you can always check MSHA's mine data retrieval system, which should indicate the deadline there. And as we note here, if this contest isn't submitted timely, the citations and those penalties will be final. And it's extremely difficult to get them reopened up. So it's very, very important if you're receiving penalties or when you're receiving penalties for any of these, that those are timely contested.
I'll also just add on that quickly is with the shutdown, nothing has been assessed. But MSHA is still out inspecting. So there are likely citations sitting there from shutdown inspections and also inspections that took place during the shutdown where you're going to have a backlog of assessments coming in. So make sure you're paying attention to that and don't miss anything that comes through. Also, if you may have submitted an informal request during the shutdown, those weren't informals were not happening. So just in general, pay close attention to what's coming in assessments because if you have a citation that you requested an informal on, but it fell through the cracks, but your assessment has come out and you have a penalty, you still need to challenge the assessment. You can't sit there and say, well, I might have an informal because I submitted a request. That's a losing proposition. File the contest and then you can sort out whether or not you have an informal. But if you don't, it will move through to a final order. So sorry to interrupt you there, Emily. I just want to be clear on that.
No, that's a good insight. Um, so just to wrap up some thoughts that we've touched on a bit here, as we discussed, informal contests do have utility, especially in kind of lower stakes enforcement actions. But especially when it comes to unwarrantable failures, there are risks, including, as Nick outlined, that statements that are made by the operator itself or by managers will be included in the inspection report and can be used as evidence to support more elevated enforcement actions. And again, we don't know at this point whether there might be a 110 investigation or even worse, potentially a criminal referral. And so, Nick and I do not generally recommend when it comes to unwarrantable failures that informal is the route to go. The contest process, the formal contest process before the commission is generally more useful and results in, frankly, more favorable resolution in our experience. Um, as we've noted here, at that point, the inspection is closed. We have the complete universe of information that MSHA is going to be able to rely on. And that also, as we discussed a few minutes ago, typically at that point, all the various contests, including any potential 110C agent penalties, will all be together. That usually provides more flexibility in determining whether there might be favorable settlement options to try to get cases resolved. And of course, we'll also know what the penalties are. So our recommendation is if you have received these 104Ds and warrantable failures, that formal contests are generally more favorable for protecting your rights and also just generally a better vehicle to get independent and fair resolution.
Yeah, and so I think that's a good wrap up. So obviously this was a one today where we talked a good bit about the ramifications of 104Ds, but I think it's just important to remember in general, when a D is issued, or when an inspector says a D is going to be issued, or could potentially be issued, that needs to perk up our ears, right? Everyone needs to understand that this isn't a normal citation. This isn't a 104A. There's potential for these higher penalties for agent cases. The company's penalty is going to be much higher. It can result in more 104Ds, which are shut down. We just have to treat them differently and address them differently. It's not normal enforcement. These are elevated enforcement actions. And so our response has to be appropriate elevated as well to one, run them to ground, figure out if there's an issue, correct that issue, and make sure that our mind is remaining to be a safe place to work. But then also marshaling our resources to begin mounting our defense. And whether that is trying to convince MSHA in the moment or immediately thereafter that the 104D is misplaced and here's some additional information that you didn't have to consider at that time, or really what is more likely is once they're issued, and then we're gathering that information in order to defeat them in the contest process and really to be prepared that if there is a 110, that we're able to defeat the 110 in that moment so that we don't even have to worry about the headache of assessments or criminal referrals or anything like that at that point. Um, one, we want to thank everybody for joining us today. If you have any questions, just a reminder, you can go ahead and submit those through the chat. But the other item is we want us to thank you for joining us for our final webinar of 2025. So we'll be taking off next month in December while we're putting together our 2026 webinar series. If you guys have any suggestions, topics that you would like to hear about for the MSHA webinar series next year, I welcome you to send us an email or submit something in the chat right now on a topic. Emily and I will be working on that with the rest of our team here in the next few weeks to get a new schedule up for 2026 and look forward to meeting and talking with you all there. On our OSHA team, we will have one more webinar here next month on new approaches to performance management and auditing enforcement on December 16th. So if you're in the OSHA field as well and think that might be a useful one, feel free to register for that webinar as well. Or as always, we will have our blogs updated and going on a number of topics, the MSHA Defense Report, OSHA Defense Report, Employer, and then if you're out on the West Coast, our specific Cal OSHA Defense Report there. Happy to take any questions, and we'll give people a couple minutes to type those in as we wait and close out here. And appreciate you all sticking with us for a few minutes past the hour. But otherwise, don't ever hesitate to reach out to us directly. We're happy to be a resource for you. And if there's any questions that we can help you navigate in terms of interactions with the agency or just things you're contemplating about what might happen in a certain situation, we're always happy to be a resource and talk that through for you. So thank you for joining us today. I see we've got a couple of comments in there, but I think we're good on questions right now. So I'll wait a couple more minutes before we shut down to see if any last minute questions come in. Probably just respond to those individually if they do. But thanks for your time, and everyone have a great end of the year and a great holiday season.